Welcome to the Arrive podcast, the U.S. immigration law podcast for Canadians. I am Jeremy Richards, and I'm here with my business partner and fellow immigration attorney, Christine Jurusik. Together, we are Richards and Jurusik Immigration Law, practicing U.S. immigration law from our offices in Buffalo, New York, and Toronto, Ontario. And we help Canadians to work and live in the United States. If you haven't already, please follow and like us on your podcast app. Subscribe to our YouTube channel, Richards and Jurusik Immigration Law, and follow us and like us on Twitter, Facebook, Instagram for regular updates on U.S. immigration law that we have created just for Canadians. In addition, on our website, there is a resources tab where you can subscribe to a weekly newsletter where you will receive all our recent updates and posts about U.S. immigration law as well. In today's episode, we are going to go over a few things. First, we're going to hit some recent updates in U.S. immigration. Then we're going to talk about some case successes that we've had recently. Then we're going to go over some frequently asked questions that we receive. And then we'll get to some submitted questions, the listener submitted questions as well. So updates. I don't think there aren't that many updates to go over that have happened since the last time we talked. I guess the biggest one would be the H-1B visa lottery is now open, and that opened March 1st, so it's been open for a week now, and it's going to go until the 17th, and it closes at noon Eastern time on the 17th. So this is an important window for those individuals who are looking for an H-1B visa, maybe changing from TN to H-1B or another status to H-1B, or maybe your profession doesn't qualify for a TN and maybe your managerial level or whatever it might be, or your profession isn't listed under the USMCA for a TN profession, then this is your time to go after that H-1B visa. It doesn't matter when you go into the lottery. So you could have entered the lottery on day one, or you can enter it at 11:59 on the 17th. It doesn't matter. Everyone who enters has an equal chance at winning the lottery. So based on past numbers of the lottery, they issued all of those. Last year was around a 15% chance to get into the lottery.
That's low.
Pretty low. Mm-hmm. So in the odds of getting into the lottery depend on how many people enter. It's looking like this year, the numbers with the hiring difficulties that U.S. employers are having right now, it could increase. But at the same time, if employers aren't as busy as they thought they would be, it looks like some businesses have declined over since COVID. A lot of these stimulus funds business. IT businesses are suffering. We've seen layoffs with Twitter, Facebook, the tech sector. So, and those are some of the biggest sponsors for visas. So,
historically, yeah, they have been.
So we'll see. Maybe some other employers jump in the ring, right, because they can't find talent, and snatch up some of those numbers. It's yet to be determined what the odds are. Probably, my guess is like somewhere in the 20% range.
Yeah, that sounds probably about right. But we should be clear, because I get lots of calls and people, wonder about this. Is who are they competing against for lottery numbers? And you're literally competing against anybody from around the world in any profession that's applying for this.
The entire world.
So. There's no specific amount of visas set aside for certain professions.
Or certain citizenship.
Or right? Certain citizenships, right. It's not specific to that. So this is a wide open lottery for all professions that qualify, and people from all over the world that qualify. Yeah,
and I'm going to pull it up now just because we're talking about it, and people might want to know the exact numbers. I posted it, and this is a plug back to our website. I posted it on our website. There was an update on there, and that's specific to the opening of the lottery. But it gives some of the numbers around the H-1B lottery submission. So, according to the past numbers, there were 483,927 registrants for the H-1B lottery last year. For the available 65,000 bachelor's level cap and 20,000 master's cap. So roughly 485,000 people entered the lottery for 85,000 spots. So that gives you an idea of what it was. So odds aren't high.
13%.
Yeah, odds are not high. And it goes up slightly if you're masters to 16%. So, and the reason is because if you have a master's, an additional allotted number for master's graduates who receive their education in the United States. So that lottery is now open. If you need an H-1B visa, now's your time to try. So best of luck to you that are entering into the H-1B visa lottery. No other updates of note.
There is one. There's
one?
The Child Status Protection Act point. USCIS has changed the dates that they're going to acknowledge children and being prevented from aging out of the green card process. And they used to say that they needed to meet the age of 21 by the final action date on the visa bulletin. And this is just a bit of technical information. And they changed that to not from the final action date, but from a earlier date or a more recent date, which would be the filing date. So that filing date is always a little bit ahead of the final action date. So that means that's going to prevent certain children from aging out of the process when they hit 21, because that clock will stop at the final action date and they won't continue ticking. So that's good news.
Yeah, and aging out, for those that don't know what that means, for U.S. immigration purposes, once a child hits 21, they age out. In other words, they're no longer considered a dependent or a beneficiary of their parents. So they can't obtain certain immigration benefits as a child
as a dependent.
As a dependent. So this would be if it's a U.S. permanent resident or a U.S. citizen sponsoring their child. And it makes a big difference if you are considered a child or an adult child.
Or, I mean, it could be more removed than that. So if you sponsored your brother or sister about 20 years ago, and they maybe had a 2-year-old at the time, guess what? That kid's aged out of the process before the visa was available for them, and that means the whole family would not be able to move together to the United States. I think we need to note that USCIS recognizes at age 21 that these kids are no longer kids, and they are, individual adults that need separate sponsorship because they have their own families and their own lives in their home country.
Yeah, and that's how the whole priority system is set up, right? They give priority to those that they see as part of, I would say, the nuclear family, right? Mother, father, spouses, children.
Yeah.
But it doesn't even go to siblings as it does. So there's preference given to your parents if you're a U.S. citizen, or your children or your spouse. Those are the ones that have the preference and that are actually exempt from a lot of these limitations as far as immigrant visa issuance. And then once you get outside of those relationships, that's where you get into longer wait times, less visas being available, and then other issues that can come from that.
Country-specific wait times and things like that, yeah.
All right. So now we'd like to move in. Let's talk about some things we've seen happening recently with some of the cases that we've been handling. So we're a part of an Immigration Lawyers Association, and we get updates on a regular basis on what's going on out there with other attorneys. And frankly, sometimes what we hear just reinforces what we know. Sometimes we learn something from it. And based on a lot of chatter and things that have been going on out there with e-visa processing specifically, I think we've been giving ourselves a pat on the back because of some of the results we're getting with e-visa processing, specifically in Toronto. We haven't seen this, but other practitioners in the area, or I guess throughout the country, have been expressing
concern
with the way they're processing e-visas, right?
Yeah.
And what they would refer to as weird denials or refusals. And we listened in on some of these, and frankly, I think the ones that were discussed were actually warranted.
It sounded like it.
We haven't experienced the same. And actually, the day that this came out, this discussion, we had received 3 approvals of e-visas through the consulate in Toronto. And if you're doing an e-visa, that's who issues the e-visa registration and the
Canadian,
initial e-visa. If you're Canadian, it has to be done through Toronto. So we had 3 approvals in the same day. One of them was an E1. So E1 is for a treaty trader, somebody dealing with the trade of goods or services with the United States. And this individual specifically is in the horse industry, specifically with saddlery, and working with leather goods for horses, as well as some unique things that this individual has created and patented that are used in the horse industry. That was approved. And then there were 2 E2 visas approved on the same day too. One of them was for
a purchase of an interest in a hotel, in more than one hotel actually, in 2 separate hotels. It wasn't a straightforward case. There were complications. The investment source was complicated. The structure of the arrangement and the deal was complicated. But we were able to lay it out so the officer understood that even though it was complicated, it qualified, and we got a successful result with that one. Similarly, we had another E2 approval. This one was for an online business for the sale of office furniture, and there was some warehousing involved in that as well. That one was a little more straightforward, did have some complications with respect to it, but both of them were successfully approved same day as the interview.
And with respect to the e-visas, so E2 visa is an investor visa, and a hotel would be probably one of the most common things that businesses and
those
purchase.
2 were very different because all 3 of them were different. The E1 was for someone who had significant trade with the United States. The hotel business was for someone who purchased an existing business or part of an existing business, and that was his investment. And then the final E2, where the officer was starting their very own business from scratch.
Yep.
So they were all very different approvals.
And the E1, when we're talking numbers, people often think, oh, do I have to invest $1 million to get this? No. This E1 with the trade here, the service that this individual is providing, off the top of my head, I'm going to say it's less than $100,000 in business a year. So not a lot of business. But there is no requirement that it has to meet a certain threshold in order to qualify for an E1. What was the investment on the hotel? Do you remember how much was the investment there?
I think the purchase price was going to be close to $1 million, but their investment amount was, I think, right around $100,000.
So, if you look at the regs and you read about e-visas, they say 100,000 or more. That's the number that they give, which isn't concrete. It can be less. So that was towards the lower end of an investment that we see, 100,000. And then the office space, and that was existing. So you can buy an existing business, already operating, already has employees.
That was the hotel had existing.
Yeah.
They already had everything.
And then the office furniture store.
Start from scratch, I want to say it was around maybe $120,000.
So both on the lower end that we see of investment amount. Mm-hmm. So people get caught up with the e-visa, wondering whether or not their investment amount is sufficient enough, right? Are they putting enough money into this investment in the United States to qualify? Well, depending on what type of visa or what type of business you're either starting or buying, again, it can be a new or existing. The amount you invest can change substantially. If you're opening, I use the shopping mall. That's probably the biggest one that I've dealt with. It was a multi-million-dollar shopping complex that was purchased. Well, that clearly meets the substantial requirement right there. But all the way down to, and I think the smallest investment amount I've seen was actually here in the Buffalo area. It was an individual who purchased it was like a hockey training facility, and it was under 30,000. So
wow, that's low.
Yeah, you can get pretty low. You have to be able to justify and explain how that investment is going to lead to the creation of jobs for U.S. workers and so on and so forth. But there's a lot of latitude given for e-visas, both the E1 and E2, that I don't think a lot of people realize. And it's, in my opinion, not the E2, but the E1 is probably one of the most underutilized visas. And a lot of people don't understand that they could qualify for it. We actually just retained an individual who'd been working with another law firm in the area who had been coming on a TN visa. And that law firm said, "Oh, we can't help you anymore. You're done." This individual happened to be a consultant, which can be a complicated situation. So they turned them away, and then they found us. And then after a brief conversation, I determined this individual qualifies for an E1. And we're able to move forward with the E1 with this individual. So it's often overlooked. That other local law firm didn't even think that the E1 would apply, when in fact it does. And actually, the E1 is a better fit because the TN is client or employer specific, where an E1, you can advise any of your clients in the U.S. You don't have to keep getting a TN for each client. You just have an E1, and it allows you to consult with any of your clients in the U.S. So those visa options, the E1 and E2 are great visa options for doing business in the U.S. We also had when we get questions about this is probably one of the emailed questions we get most frequently, or even over the phone, is, can I go from a TN to a green card? I'm on a TN, but I can't get a green card. That's usually what people say. I know that since I'm on a TN visa, I can't get a green card. And we have to correct that all the time. That in fact, yes, you can go from a TN visa to a green card. And we help individuals do this on a regular basis. And we, in fact, just had one approved this week where the individual came as a management consultant. Again, one of the more complicated TN visa categories. Had been on a TN as a management consultant for multiple years, actually. We were able to get an extension, which isn't easy a lot of the time to get an extension of that. And then go to green card through the perm process. That's where you have to do a test of the labor market, see if any U.S. workers are out there to take the position. And this individual was able to go directly from TN visa to green card and is now a U.S. permanent resident. Another TN success story for an individual who'd been denied 3 times. Were all 3 denials at a port of entry?
They were all at a port of entry, and this individual had presented multiple versions of certain paperwork to the border officer, and he was denied for several reasons. Once I talked to him, I got a good understanding of his situation, and we were able to successfully apply through USCIS, which is through the mail with the immigration authority here in the United States, and overcome those 3 past denials that he'd received at the port of entry. And now he is here in the United States with his lovely wife and starting his new position this week.
Amazing. So just because you've been denied doesn't mean it's the end of the road. Depending on the situation, we might be able to help you. And we had another one this week too, where it was after another denial. This one was actually one of the more complicated border denials I've seen. This individual was accused of having immigrant intent, working unauthorized in the U.S., studying unauthorized in the U.S., and had very limited ties to Canada. We were able to help them overcome all of those issues, return to a port of entry. We didn't even have to go to USCIS on this one. We were able to go right back to the port of entry and get approved, even despite all of these things that were against them. So some good things we've seen come down recently. If you are a medical resident performing a residency in the United States and we see this with Canadian medical residents. They come here to the United States, they perform their medical residency, and they do so. Typically, it happens on either an H-1B visa or a J-1 visa. An H-1B visa doesn't have any strings attached, so to speak. So if you come and you're a foreign resident and you use an H-1B visa, then it's a pretty straightforward process to go from that H-1B to a green card. Whereas if you come to the United States and you do a foreign residency on a J-1 visa, a 2-year foreign residency requirement attaches to that residency, meaning before you can move to a green card, you have to complete 2-year residency in your home country before coming back to the United States.
They want you to take your skills back to your home country and use them there for the benefit of your home country for a period of 2 years.
And it's an obligation that's attached through this program, through the U.S. Department of State and the countries that have entered into that J-1 visa exchange program.
Right, and when you get that, there's a designation right on your visa, so you're aware of what the requirement is. When you're done, you're supposed to go back home and use those skills.
Yeah, it says 2-year foreign residency requirement. It says subject to.
Yeah, and then it has the section of the law, which means go back home for 2 years.
And we receive questions about this because Canadians aren't subject as other individuals would be.
Well, there's a little
because
loophole
they have some
for them
loopholes that are available
due to geography.
And typically, a J-1 visa holder can't even get an H-1B visa, whereas if you're Canadian and you were on a J-1, you can still get an H-1B. So that's one of the loopholes. But one of the other loopholes is a Canadian who's living in Canada, for example. Let's say you're living in Fort Erie and you're working in Buffalo, and you return home every night after work and you just simply come to work, but you maintain your residence in Canada, guess what? That counts as foreign residence. And if you do that for 2 years, you'll meet your 2-year foreign residency requirement, and then you can apply for a green card. So the other question that arises with this is, does your time spent abroad at your foreign residence, can it be consecutive or cumulative? In other words, do you have to stay out for 2 years in a row without no breaks in that? Or can you spend some time in Canada and in the U.S. as long as that adds up to 2 years over time? And the answer to that...
I mean, that would be kind of mean if it was going to be consecutive.
Yeah.
It'd make you stay in your home country for a full 2 years.
Without breaking it.
Yeah.
You can't come to the U.S.
No vacations.
No, or you have to you have to just stay there.
That would be way too restrictive. So it definitely is cumulative.
Yes. And it's laid out that it is cumulative. And I spoke to an individual recently where this exact situation applied to them. Had come on a foreign J-1 to do a medical residency. Had completed that residency, was able to move to an H-1B visa as a Canadian, and had been sponsored for a green card. And the employer's attorney told him that he hadn't met his foreign residency requirement to go to green card because they had filed a perm and it was approved, which means that he's now able to request a green card based on that approval in U.S. permanent residency. They were saying, no, you need to spend more time in the you haven't spent enough time in Canada. You have to spend more time in Canada before you're going to qualify because you haven't met the 2-year foreign residency requirement. And that attorney told him that it was consecutive and not cumulative time. So if they were looking at a consecutive time, they were correct. I think that calculation was 500 days had been spent consecutively. But if you look at cumulative, back to 2018, this individual had met the requirement by more than 60 days and had qualified. So it is cumulative and not consecutive when it comes to fulfilling that foreign residency requirement.
I had a client that fulfilled that requirement and demonstrated that in his green card application over a period of 22 years.
Oh, wow.
Of traveling back to his home country and visiting
that's
for short periods of time.
That's the slow track.
22 years.
Holy cow.
Yeah. But he met the requirement, and he had all the information, all the passport stamps, all the evidence that he'd spent time in his home country over that period of time for a few weeks here and there, sometimes a month. But he met the 2-year requirement, even though that much time had passed. So it's definitely cumulative.
So if you're subject to that foreign residency requirement or know someone who is, then that can be fulfilled by working in the United States and commuting from Canada. We see Canadians do that all the time. It's definitely possible. You can still get an H-1B visa if you're subject to that requirement. And you can also fulfill that requirement by commuting from Canada to the United States. And it can be cumulative and not consecutive. All right, so now on to some users or some listener submitted questions. This one's a pretty straightforward. This one's an easy one, but it's a good question. People, so for us it's easy. For others it might not be. It says, my wife has a TN visa to work as a nurse in the United States. I currently have a TD visa. So a TN visa is for the worker, and a TD visa is for a dependent. The D is for dependent. So a spouse and minor children can get that TD visa. And the question is can an employer sponsor me for a work permit? So this individual is inside the United States, Canadian here, his wife working on a TN, and he's a TD. And he wants to know, can he have his own employer sponsor him for a TN visa if he's here on a TD? Yes. Absolutely. They can.
That can happen.
And the one thing to consider here is if you are in the United States that you're just in legal status. If you're in legal status, they can file by mail with U.S. Citizenship and Immigration Services to change you right over from a TD to a TN without you having to leave the United States. Or you could depart the United States, come back in, and apply to port of entry.
And I think we're making a couple assumptions here. Number one, we're making the assumption that the spouse is Canadian.
We are. And they don't provide that information, but we will assume they're Canadian.
Yeah, because in most cases they are. And the other assumption that we're making also is that they have an occupation that falls on the TN list of professions. So a couple of assumptions there. If you don't have those things, your situation's different, but it sounds to me like this person could do just what they want to do.
Yeah, assuming they're Canadian and it's a qualifying profession, then no problem. Mm-hmm. And you have two options, USCIS or at a port of entry. So yes, that can be done as long as you fit in those boxes.
Yeah, and we've done that many times for people.
All the time. Now this one's a little bit more complicated of a question. Actually, it's a longer question. I don't know if it's more complicated. But this goes back to what Christine was already discussing with the aging out and the Child Status Protection Act. So this was saying, and I'll go to the question. It says, I currently was going through the process of obtaining my green card. The petitioner is my mother, who filed for sponsorship for myself, my spouse, and 4 children. We filed in 2016, and all my children were under the age of 18 when they filed. We received our interview in 2022. My 2 oldest children were told they could not attend as they were now ages 31 and 29. So this goes back to exactly the scenario you gave, right? It can take years for these to process, and by the time they get to the finish line, they no longer qualify because they're over 21. What can I do for these children now? I have paid all of their fees and completed all of their medical. I am currently a green card holder. The 31-year-old is married. I understand I can go the route of the I-130, but is there a way to salvage the original application process and not have to file new applications?
First of all, I think we need to not refer to 31 and 29-year-olds as children.
That's a good point.
Those are adults, and they actually are considered sons and daughters. So
for immigration purposes, they're always your children.
Yeah.
Come on.
They are.
Right?
Yeah,
Even though those children we may not want to call our children anymore, they're still our children, no matter how old they get. But yes, for immigration purposes, they differentiate between children and sons and daughters.
Yes, and the age for most of these types of cases is going to be 21 years old, where they are no longer considered children in the eyes of the
under
immigration
21,
law.
You're a child.
Under 21, you can still be considered a child or a dependent on an application such as this. But once you hit that age of 21, I think their chances are over. So
But you go to a son or daughter when you hit 21 and no longer child.
You do.
So you're not dependent.
Correct. You're no longer a dependent. So I think that this inquiry had the right answer here. They said that they know they can go the route of filing I-130 forms, which is a petition from a green card holder or a U.S. citizen for their family members independently, but as they want to make sure that they keep the date. I think they're more concerned about the dates here so that these people can process at the same time. Unfortunately, there is no way to do that. What would have to happen here is once that parent of these sons and daughters got their green card, they could petition for them.
Well, in this case, it's not a
it's
child,
not even an option.
and it's a permanent resident.
So
the answer here is
no. Not right now.
You cannot file those I-130s yet.
They can when they become a citizen.
Yeah, individual. So this wait time just became very long because if you are a U.S. permanent resident, you can only file for your spouse or children. You cannot file for sons or daughters. In other words, over 21, they don't qualify. But if you become a U.S. citizen, and this individual, if they obtain this green card through their mother, they're going to have to wait 5 years. At the 5-year mark, they're going to qualify for citizenship, be able to apply for citizenship, obtain that, and then sponsor these adult children.
And that only applies if they live in the United States for the full 5 years, or most of the 5 years.
Yeah.
If they decide to stay with their sons and daughters, they're not ever going to become a citizen of the United States. And
that's a good point.
Even though this is for family reunification, it does require some family separation to go through the process.
Yeah. Well, we see that a lot, right?
Yeah.
You're the one that, as a dual citizen, you like to make this point all the time. I hear you doing it. Is make up your mind. You're either a permanent resident of Canada or the United States. You can't be both.
Right.
And we see that where this situation applies, where maybe they have a conflict because they got their green card, but someone else in their family didn't. So they don't want to come until they can all come together. Well, if you do that in this situation, you may make it almost impossible to bring those children over if you never become a citizen because you never relocate to the United States.
And some of these wait times for these family-based applications are just absolutely ridiculous.
Insane.
These people are waiting 20 years to get a visa available, even longer sometimes if you're looking at Mexico.
Philippines.
It's very restrictive, so it's definitely worth calling a lawyer to checking this stuff out. So I understand why this person was curious to see if there's another way. I would have the same question if I was them, but unfortunately, the way the law is right now, there isn't another option. Yeah,
31 and 29, no longer child. And we just had a case similar to this. Someone approached us, and the scenario was a U.S. citizen, son. The child was born in the United States because the father had worked here during his career. And the son had turned 21, which is the age which you need to arrive at to sponsor a parent if you are a U.S. citizen, and wanted to sponsor his mother, father, and sister to come to the United States. Well, those are different categories for immigration purposes. If you are sponsoring your parents, they are considered immediate relatives, and they are able to go through the process immediately. The only wait time there is processing of the applications, whereas a sister falls into a different category and is subject to visa wait times. They had an option. The son could sponsor the parents and the sister separately through I-130 applications. They're all done through separate applications in this instance. But the parents would come and they have to leave behind the minor daughter. She was 18 at the time because the wait time for the daughter would be much longer than the wait time for the parents. You're talking years longer. So the advice that we gave was have your son file for you and your wife now. Once you become a green card holder, the minor daughter would then qualify to come as your child and dependent as a green card holder. So what did they do? Well, we filed the I-130s for the parents. Those were approved. And once the father got his green card, he immediately filed for his daughter, who luckily, under the Child Status Protection Act, and we're talking it was a matter of days or months. It was a very short window that we had, and luckily made it in that window where she did not age out. So the son sponsored the father, who then in turn sponsored his minor daughter, and now they all have green cards. So something that could have taken several years was cut down to a matter of, in this case, you're talking about a 2-year time period. That's how long it took because of the wait times to process these cases.
And by several years, you mean like?
Decade.
More like 14, 15, 16 years.
Yeah, decade more.
Yeah.
Yeah.
I just a bit of personal information. When I got my U.S. citizenship, I had a brother who asked me, if he could move to the States and live here. And I said, sure, I'll sponsor you. And that I filed that application, and the priority date is 2009. He's still waiting. He's very patiently waiting to get out of the cold of Canada. He wants to get to the warm weather.
So 2009, how many years is that? He's been waiting now?
14 years. And he's got, and the priority date right now is 2007.
So 2 more years to wait.
Or longer, because it doesn't move. It doesn't move a year. So it could be another 5 years.
So we were able to use this strategy for this family to keep them together. So very valid question. And families are torn apart all the time with immigration, unfortunately, because of these visa limitations and the way they categorize mother, father, brother, sisters, aunts, uncles,
and the ages, people,
and ages. So you need to be careful when you're going through that process to see how it might impact you and prepare so that you're taking the best strategy forward. Okay, a TN visa question. You want to read this one?
Sure. I'm a computer science major student at the University of Toronto, or at a university in Toronto, and I will be graduating this June. My partner has been admitted to a graduate school in Chicago, and so we're planning to relocate there for the coming fall. I'm currently in my last semester and planning to soon start applying for jobs in the U.S., and I want to try to get a TN visa. I think that would make me more competitive candidate, since as far as I know, TN visas don't require sponsorship. I know software engineers are a gray area in the TN visa eligibility category, so I want to be sure of the details. I need to know and let my potential employer know so I can cross the border smoothly.
There's a lot in that question, actually.
There was. It sounds like this person thinks that they can get a TN without any employer input.
Is saying that TN doesn't require sponsorship.
Right, and saying that they're a more competitive candidate. You've got to have the job first.
And when you're applying to jobs, and this is why people, I don't know why they think, but it asks, do you have status to work in the U.S.? Are you a U.S. permanent resident or a U.S. citizen, or do you otherwise have a visa? We hear this a lot where Canadians click visa not required or sponsorship not required because they think for some reason that a TN doesn't require any employer input. That's not correct. Now, is it traditional sponsorship? When I say traditional sponsorship, if you're familiar with the visa process, when individuals refer to the traditional sponsorship, they're talking about an H-1B visa, which requires working with the Department of Labor, USCIS, and it's a lengthy and costly process, and employers don't want to be burdened with that and all the fees and everything that's involved in that petition process. That's what they refer to as sponsorship. Although the TN visa doesn't require that amount of work, it does require an employer to say they need you and to support you in the process. So I would say if you don't call it sponsorship, well, you still need to call it employer support. They have to support you in this process by giving a job offer.
Yeah. You can't get the TN first. That's cart before the horse. You've got to have the job offer.
You can't be self-employed.
Right.
So you absolutely need an employer. So you can't cut your employer out of this process.
Right. Now, what about this part here where they say software engineers are a gray area in the TN visa eligibility criteria?
I would say prior to the issuance of what is called the Cronin Memo, and was issued in July of 2000. So prior to July 2000, it was a gray area.
Maybe this is some old information they found. But yeah, software engineers are not a gray area in the TN eligibility criteria. I understand they're not set out separately on the list like every other profession, but they're identified as a legitimate TN profession. There's nothing gray about them. The requirements for a software engineer are just as clear as they are for any other occupation.
And you just nailed it. I think the confusion is it's not specifically listed software engineer, computer engineer. It just says engineer under the USMCA. So people are like, oh, it's not listed. Well, I'll read you a part of this memo. This is what is referred to as the Cronin memo. And it says, an individual engaged in business activities as a software engineer at a professional level that requires a bachelor's degree or license may qualify under the profession of engineer under the NAFTA. And that's now the USMCA, which adopted NAFTA. So it clearly states in there that software engineer follows under the category of engineer. You can get a job offer or have a job title that may not be specifically spelt out on the USMCA profession list. However, your duties and what you perform or asked to perform by your employer falls within one of those professions, even if it isn't exact title match. Right. And we say that a lot, where your profession may not be specifically listed as far as you know, but what you're doing, your duties, your education, and what that requires falls in one of those professions. So it's not always as clear cut as, oh, my profession isn't listed.
Yeah, and we should say that I know in this question, this individual is trying to stay together with their partner. We do get a lot of calls like that, and sometimes people do qualify and sometimes they do not. I had a call just yesterday with a young couple, very similar situation to this. And in fact, I think they were actually looking at going to Chicago as well. And the one partner had a degree and had an offer and had, a path to a visa, although it was unclear which one that was going to be. He was assured that they had immigration authorities or counsel that were going to take care of him, but she didn't have anything. She didn't have a TN occupation. She had a bachelor's degree, but it wasn't in one of the areas that she could get a TN for. So we had, I had to talk to them and advise them, about the different ways that she would be able to join her partner. It didn't fit in perfectly with her plan for herself, but at least we were able to come up with a plan for her to be there for the 2 years or whatever it was going to be while he was going to be working there on this contract. So, sometimes you might have to make a little bit of a career switch or modify your plans in order to make something like this happen.
Yeah, and every time I hear partner, I wonder what that means, because people say partner, that applies to many different relationships, yeah. Right? What do you mean by partner? Because that can change this too. If they're not married, then
I think that's what
you don't
means.
even qualify
I think
as
it just means they don't have a marriage certificate right now. So they may be a common law relationship, or they may just be boyfriend and girlfriend.
And then that raises common law, right? Mm-hmm. In Canada, although common law might be accepted, Canadian common law is not accepted in the United States. So that's just another thing to think about here. If you were thinking, maybe I don't qualify for a TN, so I'm just going to come on a TD as a dependent, well, you need to make sure you have that right relationship in order to qualify for a TD. In this case, you would have to be legally married.
Yeah, there's a lot to unpack with that one, for sure.
So in a nutshell, software engineers, computer engineers qualify for TN status under the category of engineer. Definitely possible. And you do need employer input support for a TN visa process. You cannot self-petition. You can't just show up at the border and request a TN as an engineer in the United States, software engineer, without an employer supporting you in that. Final question of the day. I'll let Christine read this.
Okay. The employers, when I was in grade school, I was a pretty good reader, and that used to be my job in the class when the teacher was too preoccupied with something else or just wanted to take some time off. They would ask me to read to the class, so apparently I'm good at this. The employer's job offer letter is missing the end date. The role doesn't exactly match the list of professions, and the employer is refusing to write a support letter to clarify these details. Wondering what my options are.
Another one, and I will say you do read the questions way better than I do. So, at
least
a lot to unpack in this one.
I'm useful in some way around here, I guess.
Well, yeah. So the employer's job offer letter is missing the end date. So is that a deal breaker? No end date?
Not necessarily.
Yeah.
I mean, you can frame it in different ways, but if it's a permanent position, if it says anything like that, it could be an issue.
Yeah, I'd say that's so the officer just needs to know what the time frame being requested is. So if it doesn't have to end date, it has to state a duration.
Correct. Yeah, it has to have a duration. Doesn't
and it can
need
be
to
from
necessarily
1
be a
to
date.
3 years, and like you said, it can't be permanent.
Right.
So it's a temporary time period from 1 day to 3 years. So if it doesn't have an end date, well, it should have a start date, and it should say how long they need you, 12 months, 18 months, whatever it might be. The officer needs to know exact time period for which they're requesting it. And the role doesn't match, which I don't know what that means. The role title, it can mean a lot of different things, doesn't match the list of professions. Again, this could go back to the previous question, software engineer. Well, it's not specifically listed under the USMCA profession. Well, it doesn't necessarily mean it doesn't qualify, right?
Yeah, and we get plenty of calls from people that are like, oh, well, my job doesn't match a TN profession. And you ask a few questions, and it turns out it's exactly a TN profession. It's just the title is some weird internal thing that they want to call you. And so it is really a TN, applicable job, and you can get a TN for it. We just got to somehow work within the confines of that title that they give you internally, or leave it out altogether, personally.
And I'm just thinking about the TNs we're working on right now, at least the ones I'm working on right now. Almost every one of them, we have to work through the duties, and they have an internal job title that's on the offer letter.
Yeah.
But it's not the profession they're working under. It's just what they're called by HR.
Yeah, and sometimes it's misleading. Sometimes it's not, but you got to be careful with that.
In plug for our website and our resources page on there. A lot of these questions are answered on there. Does your job title matter in a TN application? And it absolutely does. The job title does, because it can trigger the officer into going down a certain path. If your job title doesn't match one of the professions, it could be a red flag. It may not be. In the end, it comes down to your duties. So if your role doesn't match, well, and I'm assuming role means, it could mean title, but it also could mean duties. So if you have to look at that closely, and do your duties fall within one of those TN professions? If it does, it could potentially work.
Could. There are plenty of employers out there that want to hire Canadians to come into the U.S. to do these jobs, and a lot of these employers don't offer sponsorship or any kind of support with respect to the immigration process. If that's what the employer is saying and they refuse to even write a support letter for you, that's not a good job to get a TN under, to be honest. You should start looking for another position. That means this employer isn't willing to go the lengths it takes to get you there. So it's time to look for a new job with an employer that would be open to that.
Yeah, unfortunately, you cannot overcome that. Because, again, going back to our last question, you can't self-sponsor. So if the employer's not going to write you a letter...
I think a lot of employers just say,
like?
here, we're going to give you this job offer. Now go to the border with this. It's worked for other people before. It has everything you need. But our possible clients are very savvy. There's a lot of information out there. So they know when they can see a deficiency in a letter. And if they ask for changes and the employer's not open to that, it's time to walk.
Yeah. And we, again, back to our website, we have a post on there that talks about the difference between an offer letter and what we refer to as a support letter. And that's what this is here. It's a straightforward offer letter, which doesn't contain the amount of information sufficient to apply for a TN at the border. And if they're not willing to modify that or provide an additional support letter, is what we refer to it, to supplement that offer letter, unfortunately, you're out of luck. And like you said, you need to find another employer or help them understand the simplicity of the process. And sometimes we can intervene, and I did that recently. Just had someone retain this week where the employer didn't understand the process. We were able to walk the employer through the process, and that, hey, this is all going to align with the job you've offered them. Mm-hmm. However, we just need these details in this letter in order for them to get the visa. You don't need to do anything. We'll do all the work for you. We'll draft the letter. It'll have all the necessary components. We'll provide it to you. You just sign off on it, give it to them, and then they'll apply for their visa on their own.
Yep, and some employers are open to that. We'll even make changes. Sometimes they come back and say, oh, we don't like the language here, we don't like the language there. They're very in tune with what could be construed as contractual language. So we'll make those edits so that the employer is comfortable signing off on it. And in most cases, it works out. But if your employer won't even, go to that level where they want to get an understanding of what you need, that's probably not a good TN option for you.
Thank you for tuning in today to the Arrive podcast. Hopefully you enjoyed the conversation and learned something. I think I learn as we discuss and talk through things sometimes. And the questions are always appreciated. Thank you for submitting questions. If you have a question you'd like us to answer during the podcast, please submit it so that we can address it on a future podcast episode. If you haven't already, please subscribe to our podcast wherever you listen to your favorite podcasts, and tune in next time.